Should your parents put their house in a trust? For many parents who own real estate, a revocable living trust is worth discussing with an estate planning attorney because it can keep the house out of probate, preserve privacy, and give heirs a clear person to manage the property after death. The key is not just signing a trust. The deed has to be recorded in the name of the trust. Who am I and why does this matter? I am Rhett Fruitman, co-founder of Inherited Property Match. My background includes City Private Bank, CBRE, and helping families navigate inherited property sales across the country. This is general information, not tax, legal, financial, or real estate advice. Before you sell inherited property, speak with a CPA and, when probate or trust administration is involved, an estate or probate attorney. What does a revocable living trust do? A revocable living trust lets a parent keep control of the home during life while setting up a successor trustee to manage it if the parent becomes incapacitated or dies. The parent can usually live in the home, sell it, refinance, or change the trust while alive. After death, the successor trustee can usually act without a probate court appointment if the deed is in the trust and the title company accepts the trust documents. That is the main advantage over relying only on a will. Does putting a house in a trust avoid probate? Yes, a properly funded revocable living trust usually keeps the house out of probate. Funded means the deed was transferred and recorded in the trust's name. If the trust exists only on paper and the deed still lists the parents individually, the house may still need probate. So the most important question is simple: what does the recorded deed say? Families should pull the current deed from the county recorder, not just assume the trust owns the house because the trust document mentions it. What happens if parents do not use a trust? If the house is titled only in the parent's individual name at death and no survivorship or transfer on death mechanism applies, the property often has to pass through probate before heirs can sell. Probate can mean court filings, a personal representative or executor, public records, creditor steps, and delays that may last months or longer. A trust, TOD deed, joint tenancy, ladybird deed, or LLC may avoid probate in the right situation, but the deciding factor is title. Title controls the path. Is a trust better than a will, TOD deed, or joint tenancy? A trust is usually stronger than a will for real estate because a will still goes through probate, while a properly funded trust can avoid it. A transfer on death deed can be simpler in states that allow it, but it does not handle incapacity and may be weaker with multiple heirs. Joint tenancy can avoid probate, but it can expose the house to a child's creditors, lawsuits, divorce, and tax or Medicaid complications. A ladybird deed can work in some states, but only if the state recognizes it and a title company will accept it. When does a trust make the most sense? A trust becomes more useful when there are multiple heirs, property in more than one state, a blended family, an heir who may not be ready to manage money, or a parent who wants one decision-maker for the house. It can also help if the family wants instructions for whether the home should be sold, kept, rented, or offered to one heir through a buyout. A trust is not just a probate tool, it is a management tool. When might a trust not be necessary? A trust may not be necessary for every family. If there is one house, one heir, no conflict, and the state allows a clean transfer on death deed, a TOD deed may be enough. A trust also may not be worth the cost if the family will not follow through and record the deed. The right question is not, is a trust always best? The better question is, what title plan gets this specific house to the right person with the least court involvement, tax risk, and family conflict? Can a house with a mortgage be put into a revocable trust? A standard residential mortgage often allows a transfer into an inter vivos or revocable living trust when the borrower remains a beneficiary and occupant of the property, but families should review the loan documents before recording a deed. HELOCs need lender review too. A reverse mortgage requires special care because death, vacancy, and title changes can trigger repayment or servicing issues. Do not record a deed change before the mortgage, insurance, and legal issues have been checked. Does a house in a revocable trust still get stepped-up basis? In many cases, yes. A house held in a properly structured revocable grantor trust is usually still treated as the parent's asset for tax purposes, And heirs may still receive a stepped-up basis under IRC Section 1014 when the parent dies. A revocable trust does not eliminate estate tax. As of 2026, the federal estate tax basic exclusion amount is $15 million per person, but state estate tax or inheritance tax rules can have much lower thresholds. Families near those levels should speak with a CPA and estate attorney before relying on assumptions. Does a revocable trust protect the house from creditors or Medicaid? No, a revocable living trust does not usually protect the house from the parent's creditors or Medicaid estate recovery. Probate avoidance and long-term care asset protection are different goals. If the concern is nursing home costs, Medicaid eligibility, estate recovery, or creditor protection, the family needs elder law advice, not just a standard probate avoidance trust. Some families need an irrevocable trust or another plan, but that is a separate conversation and it has different trade-offs. How do parents put a house in a trust the right way? The right process is to hire an estate planning attorney, create the revocable living trust, record a new deed transferring the house into the trust, notify the lender and insurer when appropriate, and review the plan every 3 to 5 years. Also name a successor trustee and a backup. The trustee may need to secure the house, pay bills, communicate with beneficiaries, hire a broker, review offers, sign closing documents, and keep records. Choose someone who is organized, available, and trusted by the family. What is the bottom line? For parents who own real estate, a revocable living trust can be one of the strongest tools for avoiding probate and giving heirs a cleaner path after death, but only if the deed is actually transferred into the trust and the plan fits the state, the mortgage, the tax picture, and the family. If you inherited property and need help finding a broker who understands probate, trust, and estate-related sales, Inherited Property Match can connect you with a vetted broker experienced with inherited property. The match is free.